Welcome to our sixth Contentious clinic. Today we have Martin Holdsworth hosting for us, who is the CEO and founder of IDR Law. The topic today is Larke versus Nugus requests. So this was actually high on demand from our IDRN subscribers. We did a survey recently which asked what types of CPD that you wanted to see, and top of the list was Inheritance Act 1975, which Eleanor Stenson covered a few weeks ago. So if you haven't seen that one yet, that's in our CPD section on the IDRN. And second was Larke versus Nugus requests, so the dreaded requests that you can sometimes land on your desk. So that is what we've asked Martin to host for us this month, as he is such an expert on the topic. So I'm going to hand over to Martin, and he will crack on with his session on that.
Thanks, Lindsay. I'm hoping everybody can hear me all right. I'll just get the nod from Lindsay to make sure that's coming through.
Okay. Yeah, I can hear you.
Super, and you can see the screen slides as well. So that's a good start.
Just a quick one, sorry, Martin. What I did forget to mention, if anyone's got any questions, then if you just pop it in the chat and then we'll address them at the end of Martin's session. Thank you.
No, just about to say, Lindsay, thank you. Thanks everybody for joining us. This is the first clinic I've done, of this type of clinic anyway, that I've done before, and I'm pleased to see that it's well attended. So I'll try and give some return on that investment of your lunchtime while you're eating your sandwiches. Just by way of a brief introduction, is that somebody, Colin, who needs to turn his mute on. I founded IDR Law in
I just haven't got it in my diary, that's all, and I've put it in now.
I carried out my first contentious probate case back in 1993 as a trainee solicitor, or an article clerk as it was back then. And as you know already, IDR Law is the only firm that deals just with contentious probate. And in fact, that's all I've been doing for many, many years. What I wanted to try and cover off today, and really the objectives of this, is the start point of where claims normally are when you see them at your end. So I thought I'd summarise the objectives right at the beginning, see if we can hit those by the time we get to the end of the 50-minute session. So objective for me here is to try and share with you our knowledge and experience in dealing with Larke versus Nugus requests, to provide some context and pointers on how to deal with those requests, and then hopefully highlight some ways in which you can make things easier for yourself in responding to those requests inevitably when you get through them. So what I wanted to try and do right from the outset is put a little bit of context to this. And I think I got my first Larke and Nugus request probably 15, 20 years ago, but they've certainly increased in number to the point where about 4 years ago, in 2019, I decided to run a survey to see how many other people were getting these, in what volume, and what did they look like. So we completed a survey, and I'm going to talk about that survey at various stages as we go through today. But the survey was very well received, actually. It was only a Survey Monkey one, but we sent it out to 40 different companies who all responded as a cross-section. It had sole practitioners right up to what I believe is still the biggest will writing company, throwing out 250 wills a month. And the questions that were in there before was things about how many you got, when you got them, how long did it take you, those type of questions. And I will come back to them. But what I was going to try and do is, we've got 50 minutes, is could everybody who's on this call, I'd like to compare to see how over the last 4 years, with the intervening COVID, etc., and the publicity that these type of claims now get, have we seen an increase in the number of Larke versus Nugus requests coming out? I think anecdotally, I suspect the answer will be yes by everyone. But let's throw a little bit of science on this. So what I'm going to ask everybody to do is that if you haven't had a Larke versus Nugus request land on your desk in the last 12 months, can you just message Lindsay a no? And I think if you can do that, Lindsay can then count them up before we get to the end of the session, and we can work on a percentage of those people attending and those people then who haven't had a Larke and Nugus request coming through. So that will give us something to compare where we were 4 years ago. So if you don't mind sort of appeasing me on that, I think that might throw up some quite interesting information, and we'll take it from there. So back to the beginning. the beginning of Larke versus Nugus. Larke versus Nugus was a case that you will all know about. And the important bit, really, the complete conclusion of why we're having this talk is surmised there. So essentially, if a will you have prepared is disputed, you may be asked to disclose information about the circumstances surrounding its preparation and execution. What I would say immediately about that statement is that the emphasis for me is more on the if, more than the may. So if a will you have prepared is disputed, it's that sentence really where you'll see the focus really goes on. It's a conditional requirement, because if the answer to that if is no, so if the will is not disputed or it doesn't get classed as a dispute, then you can ignore the rest of that sentence. It's a conditional requirement at the front end. I don't think the reverse is true. I think the reality is that if a will you have prepared is disputed at a level where a Larke and Nugus is appropriate, then I don't think it's going to be a may. I think it's actually going to be a will. You know, if you've already been asked about this, it's highly likely that you're going to be asked to disclose the information about the circumstances. And of course, because you've got through the first condition, you're going to have to do it. So I think really the emphasis on that statement is on the if rather than the may going forward. And as you will probably be aware, IDL, we've got 16 lawyers that just do contentious probate. We throw out quite a lot of these, and most of our Larke and Nugus request letters run to something like 26, 27 different questions. And I wanted to be sort of absolutely clear at the outset is that beyond a no illusion, there's only one reason why Larke and Nugus letters are sent out. It's because a client has taken a view, a disappointed beneficiary or a disappointed non-beneficiary, that they do not believe that the particular will that you have drafted is valid. So the primary purpose, as I've stated there, is that the LVCN request is to obtain evidence from you that the will you drafted should be declared invalid. And that evidence that's contained in that will file, as I comment there, is the only contemporaneous bit of evidence relating to the disputed will, of course, because the best witness, I've always say, is unfortunately always dead, because the person we want to speak to is the person that's made the will, that's spoken to you. You spoke to them, you looked after them, you took instructions, and you had a will executed with them. So that information is always going to be crucial when deciding whether or not a will should be declared invalid or not. And in fact, I've quoted one of my good friends, Tom Dumont. He actually feels it's so important that he refers to it as the jewel in the crown of contested probate procedure. And I think that's because it's the deepest level of evidence you are going to get that isn't self-serving in some way, because it actually is just about the individual themselves. So I make no bounds about it. People receiving these letters, and we advise people in terms of sending them out and also receiving them. Nobody enjoys receiving them, but you have to deal with them. Or do you? Well, a couple of sources here. The latter of which got thrown out just in the middle of me preparing for this talk today, which was an updated Law Society practice note, which has only just come out. So it came out on the 5th of September 2023. It's an updated practice note, and essentially it is guidance to solicitors, which extends, of course, to will writers, that enables them to give consideration and help them through the question of whether or not they should respond to a Larke versus Nugus. As you can imagine, it only goes so far, but certainly the most recent practice note is a lot clearer and a lot more helpful than the previous one. So if you come away from nothing from this other than I'm going to go and download that, then I certainly would recommend that that's a good step to make. I mean, one of the things we will do is we'll drop a copy of it onto the IDRN so you can download it directly from there. Now, that note refers to Larke versus Nugus. And as you can see, Larke versus Nugus is 1979, reported again in 2000. And it was all to do with whether or not privilege could be waived when having to deal with a will that was in dispute, and that will was the subject of that privilege. Worth remembering that first bullet point. I think personally that gets lost in a lot of court proceedings, is that the court's role when dealing with wills is an inquisitorial one, not an adversarial one. And as I say, there's not many disputes you get involved in that don't feel adversarial, but one has to remind ourselves that it is the court's job to be inquisitorial about it. And probably the best example I can give you of this is that normally with civil litigation, you have two parties, and both parties present an argument, a claim and a defence or a counterclaim, and the judge then decides which party it believes is correct and finds in their favour. In terms of an inquisitorial approach, there's a third element to it, that the judge is perfectly within his or her rights to hear of those arguments and decide that something completely different. So he doesn't, or she doesn't have to decide one or the other is right. It's an inquisitorial approach, and they've got to decide themselves on behalf of the court. We are satisfied which will is valid and why. So there is a slight difference there. And I think in terms of Larke and Nugus and responding to it, I would suggest that if those people on the call have a look at the practice note, the new one, you will see in there, there's actually a decision tree. I mean, that's very forward thinking and very helpful, actually, because what this decision tree does is goes through a yes or no. So basically, it will ask you a series of questions, and it's all set out, as I say, as a postscript to the actual note itself, is this person this? Yes, no. If the answer is yes, then you can disclose. If the answer is no, you go on to the next one. And it takes you down about 5 or 6 different examples, and it deals specifically with whether or not you have authority to respond to the Larke versus Nugus. What do you need to do to fulfill that authority requirement before you respond to the request? It's quite limited, but nevertheless, it's a great start. And my view is, and Lindsay might hate me for this, is that if the feedback of today is that actually that is quite useful, but what will be more useful is an extension of that decision tree so that you can find out immediately at the end of it whether or not you need to respond and how, then we can build that as an app. I mean, we've got lots of software apps at the moment under development, but that for me is half done already by the Law Society, is something we can look at doing. Feedback at the end place. In terms of first considerations, well, preliminary considerations here is that one assumes that if we're talking about a Larke and Nugus, you've had some kind of correspondence, usually from a solicitor, and that solicitor's letter may or may not say Larke versus Nugus request either in the heading, or it could appear in the body of the letter. It doesn't actually have to have the name in it at all, but it's quite helpful. If they do declare, you'll find that ACTAPs have on their website, they have a stock one that you can use, so that's quite useful. But again, the purpose behind this is we are representing a party who has a serious dispute in connection with the will which you yourself, and it's directed to you, you have actually prepared, arranged, drafted, and had executed. And when you receive this, I mean, your first reaction is always, good grief, this is just horrible. No one enjoys receiving them, because you know at the very least there's a pile of work to be done, and at worst you're having to go down rabbit warrens trying to find files and the rest of it. Is before you respond, you've got to decide whether or not, and this is where the decision tree is quite helpful in the Law Society practice note, is do I have the authority, do I, the will writer, have the authority to respond to this request for Larke and Nugus? And there are 2 duties there, really. Is that the first is that you owe a duty of confidentiality in relation to the matters that you were retained for. And in addition, there is, of course, legal professional privilege, which attaches to the communications between solicitor and client. Now, the distinction between the 2 is not always so clear. And in fact, I'll add a third sort of sweeping one, which is privacy. But so you've got this situation where, is this confidential? Is it privileged? How do I deal with both? Are they the same? And how does privacy hit over the top? And of course, with privacy invariably comes data protection, GDPR, and the rest. So one has to be very, very careful. It's blurred, and a natural reaction is either to tell them to go and take a running jump, or actually, dear me, I better give them the whole information. But I think what I would like to encourage is people just to take a breath, just to take stock, try and take your own personal feelings out of it, because that's probably the hardest thing. Take that out of it and then go slowly. And the first step is the one that probably most people forget, which is the authority position, is do I have the necessary authority to respond? Now, the authority can come, and I've listed 5 ways in which the authority can be given to you to respond. And the 6th is just dealing with a personal data request. But the first 5, number 1 is quite unusual. You could get given the authority by the person, the testator or testatrix, who actually made the will in life. Really unusual. I can't actually remember a time where I've actually seen it, but there's no harm. You can have on your file a clear authority saying, if in the event of my death, a request comes in to see the file, then these are the people I'm happy for you to pass it straight on to or not. Because, of course, what we're saying is that the authority of the deceased is what passes on to you, and therefore do you then pass it on to them. So for me, really unusual. Might not be, could be quite helpful. I know we'll talk about some Larke software at the end, but Larke is something that does deal with that particular question, is that if you asked your will clients, in the event that a claim comes in, is there anybody that you would be happy for me to disclose this to straight away? And ask the question, and down it goes, and that might help you further on. The more likely is number 2, which is that the PR, the personal representatives of the estate, it vests in them. So the right to confidentiality, the right to privilege passes on the death to the PRs for the deceased. Worth remember A and B, these are all the exam questions you get in your step exams, and the rest is that don't forget that the PR comes through to an executor from the will itself from the date of death. So there's an automatic vesting of that. Whereas PR for an administrator comes from the actual grant of letters of administration itself, which of course then throws up problems, because invariably if you've got a Larke and Nugus letter, you can bet your bottom dollar that there's also a caveat that's being lodged there with it. And how do you get a grant if there's a caveat? But I'll deal with that a little bit later. Third, authority. If you've got, say, for example, you have a claim coming in and it says that will is not valid, and in fact, as a result, you are not the executors, or the executors named in that last will are not the executors. They are somebody else in a previous will. So you have this dispute about both sides alleging that, well, if our will's right, we have the right in respect of privilege and confidentiality passing to us. And you can't have 2 people asserting the same confidentiality and privilege. So what tends to happen in those cases is that one easy way around it is to contact all the beneficiaries of the estate who are affected by that particular claim. Because if all the beneficiaries of the estate all agree, yes, we agree that this should be disclosed and a response should be given, then of course that's enough for that confidentiality and privilege to pass and allow you to respond to the Larke and Nugus request. One has to say, of course, is that what are the chances of all the beneficiaries agreeing anything, least alone agreeing that a will file should be released, particularly if the latest will file is the one that you want to rely on. But nevertheless, it's there. And more importantly, you can start to force some cost consequences by insisting that beneficiaries cooperate with this. And if they don't, court applications will be made and they may well be subject to adverse costs order as a result. So, and that neatly leads us on to number 4, which is an order of the court. So a court always has the power to order that you disclose something. And in particular on this position, you would be, it'd be an application to court, normally something like a subpoena. You could be, worst case scenario, you could be witness summoned effectively into court to give evidence about your will file. Again, I've seen it happen twice in 25 years, so it's quite rare that it gets to that kind of level, but nevertheless, it is the ultimate sanction that the court can impose itself upon. And it's worthwhile remembering, of course, that if a probate dispute is actually issued, then one of the jobs of the PR is to submit a statement to the court anyway, setting out all the essential information that's listed in the regulations and the rules, which requires them to provide a copy of the original will goes into court together with estate accounts and various other information that will help the court when deciding in connection with the dispute. So 5 and 6 are catch-alls. So any other statutory authority that comes in that's non-obvious, to be honest. And number 6 is something that I'm happy to deal with probably on a different conversation, because that will be an hour on its own. But the key ones here are 2 and 3. The most common one, of course, is 2. So having worked out yourself whether or not you have authority to respond, and what I would say is if you're struggling to make that decision despite any decision trees and apps and the rest of it, get some advice. Talk to somebody that and we can do that for you, but talk to somebody who can help you there. First line always comes as a surprise to somebody on this is so you've got the authority, you can if you want to, but should you? Should you, and do you have to respond to a Larke versus Nugus request? And the answer is no, is that there's no duty to comply with any Larke versus Nugus request. The reason why people do, and people very often are advised to do so, is because set against this no duty if you don't want to exists a very real duty, and that duty is to make every effort to avoid potentially costly litigation. So if the court takes a view that if you'd have disclosed and responded to that Larke versus Nugus request, it was so obvious that you could provide the assistance to the court that would allow a decision to be made, and you refuse to do so, then the court has made orders for costs against the parties so not helping. So you have this almost self-policing through admonishment at the end of how and when and should you respond to a Larke versus Nugus. It puts it very firmly in your court. The answer is no, I don't have to respond to it, but I do recognise that where there is a dispute that could get very expensive, I may well be able to assist the court and the parties by providing the response and the statement. So you have to. It's as simple as that. If you don't, you are leaving yourself in a position of risk. But counterbalance against that, of course, and again, it's self-policing, is, but if I disclose something inappropriately because actually the dispute is not serious enough, then I run the risk of a breach of duty in respect of confidentiality being breached and privilege. So it's a balancing exercise between the 3. Where do we go for help? Well, the reality is Larke and Nugus itself provides a bit, and I've quoted there the bit that I'm hoping might help, which is where a serious dispute arises as to the validity of a will beyond the mere entering of a caveat. That in itself is not enough. How many caveats have we had that we warned off? And the solicitor's knowledge makes them a material witness. Well, that's always going to be right. Then the solicitor should make available a statement of their evidence regarding the execution of the will and the circumstances surrounding it to anyone concerned in the proving or challenging of that will, whether or not the solicitor acted for those who were propounding the will. So essentially, if you've got an interest in that particular will being valid or not, so that's previous beneficiaries, existing beneficiaries, anybody affected by a probate claim, then they can make the request. And if it amounts to a serious dispute in connection with the validity of the will, then you are in a position where you will be advised to make a statement. And that statement will bring in all the circumstances. We can help and assist doing that, explaining why, answering the questions. You are perfectly entitled, just because you answer one question, you don't have to answer them all if it's not relevant. Your job is to try and help the court. So you can say, look, I can assist the court by providing a full statement. And very often we do that, is that rather than answering the opponent's questions, is that we just provide a witness statement setting out the whole course of events from instruction gathering, preparation, execution, and through. And we keep it in a nice, neat story rather than just simply responding to a narrative that's been put together by a claimant. So as long as you cover the things, that will work fine. The statement itself needs to be of a statement of truth. So it's capable of then, once it's in court, it's taken as your evidence. So make sure it's right, because if it's not right, then you could be deemed to have been in contempt of court. So again, never seen that happen, but nevertheless, I suppose it is the catch-all at the end of all of that. Some practical points. I did promise some practical points. When you get this letter coming through, I sort of semi-joked when I said take a step back and take a breath. I actually mean that, because I think what's really difficult when you're receiving this is not to take it personally, not to be worried, and I'll deal with that in my next slide, but you need to make the call with a level-headed kind of mind. And for me, I would always advise private client teams to refer to each other, let somebody else, a colleague, make that call rather than you. It might not always be possible because, of course, one of the things about Larke and Nugus is it's specific to the person who did it. The person who did it, your firm may no longer be there, your company, they may have moved on a little bit. So you can be objective about it. But certainly objectivity is key, particularly at this stage, because you've got to decide whether there's a dispute communicated, which there always is, and whether or not there is a serious dispute communicated, which is the bit that is the decider as to whether or not you should respond or treat it simply as a fishing expedition for evidence of some type of some claim that may or may not be there. You will also find that Larke versus Nugus is misused by people trying to pursue non-validity type claims. Will files are always really helpful evidence. They are the crown jewels, there's no doubt about it, in any litigation. But if you're not challenging the validity of the actual will itself, so you're not invoking the court's decision that, yes, absolutely, we should be getting this information very early on and a full statement from the maker, is with other claims, you might just need it as evidence to support what you think happened, or in a 1975 Act to get some idea about what obligations and needs and resources were actually in existence at the time the will was done. Is there any reasons or explanations as to why a particular type of bequesting or will structure was taken on? And that's brilliant. It's really useful evidence. And the will file will always come out somewhere along the line. But it's important at this stage for Larke versus Nugus requests is that they're not true Larke versus Nugus requests, in my view, unless it deals with the validity type claims. If they're asking for that same information, but in relation to other types of claims, then actually what they're asking for is early disclosure. Now, of course, that does feed into that general duty to try and help the parties avoid expensive litigation. So I'm not saying it will be a no straight away, but what I am saying is that there is a definite distinction between the two. One of the things that we've designed and gets launched at the end of this month is a online claim checker, and it's directed really partly at this kind of philosophy of, well, how do you know at first blush, at first sweep, whether this thing has got merits or legs, or do I need to understand it? And what we've done with this particular claim checker, which is focused entirely at charities for now, the next one comes out in a month's time, but the charity version of it essentially deals with that Larke versus Nugus request, or that actual claim letter that's coming in, that's making all kinds of questions and issues, and it focuses on, okay, give us the information and we will give you a case assessment as to merits and strength. Very similar crossover here to the Larke versus Nugus is that if you've got teams internally, take them up on it. Go and get somebody to give you an objective view as to whether or not you can ignore it, tell them to go away, ask for more information of the actual claim itself, or to give a full response. Human nature is such that there is absolutely no doubt that the first thing, or one of the big things you feel is some kind of personal angst about what has come through. I've clipped in there a response to question 2 of the survey. I'm hoping you can read that. It's quite small on my screen, but hopefully it's bigger on yours. Is that the question we asked was, when you received a Larke versus Nugus request, what were the problems that worried you? What first came into your head? What did you start to get really worried about when it landed? And what you'll see there, I'll read out the sort of y-axis there, is the top one is not being able to find the file in the first place. So there was a good 12% of people worried out of everybody was asked about that. Your client's will is changed in some way. So that again was put in there. Poor will file notes. So a good third of people were worried that, gosh, I hope my notes are correct and up to date, and I've said everything and done everything and recorded everything that I should have done. Not being able to remember less, interesting enough, rather than the poor file notes. I think the view is, if I don't remember, I don't remember. Not being able to make contact with the will maker. Again, as staff turnover and the like, that's quite difficult at times, and it can be time consuming and expensive. Negligence claim being asked. So what you've got is, I'm worried about a negligence claim on the back of what I've got here. Again, I think that's a very human reaction. And then the biggest one, which I think is the reality for most people, is that the lost time, money, energy that goes into responding to this request that's coming in. Do I need to report this to my PI insurers? I get asked that a lot, actually, is that if a claim comes in, do I automatically have to refer? And my response is most Larke versus Nugus requests will not trigger a report to your PI insurers. I add the obvious caveat that, you know, this is down to you. If you're worried about it at all, you should report it. But in terms of would I be reporting it, I would only be reporting it to my PI insurers if there was some explicit or implicit claim of negligence in the actual Larke versus Nugus or claim letter itself. At that stage, I need to put my PI insurers on notice. Most Larke versus Nugus requests just want to know about who was there, who provided instructions, who paid the bill, what were they wearing, what was the demeanor, the nature of the actual individual concerned, how long did it take you? Lots of questions that are very factual. What you won't get in there is a conclusion. You have been negligent, because they're actually asking for information to make the decision from. But that's not to say that you don't get what we describe as the kitchen sink kind of letters that come in accusing you of everything and wanting everything from you. And they may even drop down that classic line that says you may wish to put your professional indemnity insurers on notice of our claim. Yeah, if that line's in there, you have to refer, even if you're referring it with a covering letter saying there's nothing here, but I have to send it to you anyway. Worth considering, though, can't ignore it. One thing it does throw up, of course, is that, and I'm not suggesting that some firms do this deliberately, is that if you are acting for the estate, if you actually drew up the will, you potentially can be a witness, an important witness in the actual dispute that may arise further down the line. And as such, you are got to be careful about your conflicts of interest here, because you owe a duty of care to the deceased client, therefore the PRs, to do your job properly, etc., and look after their interests. But of course, you owe a duty to the court as well. You bring into that some kind of self-interest, conflict of interest problem as well. If you feel like maybe this has not gone quite the way I wanted this will to do, I can see there's a difference between the instructions that I was given and the actual will that was produced. I missed something. Maybe we should look at rectification because I've got this completely wrong. You can begin to see how very quickly the waters can get very muddy in terms of conflicts of interest. And it's worth, again, right at the beginning, looking at it and taking a view. Can I be neutral? Can I work in a way and respond to this in a way that doesn't cause problems further down the line? When you get it, one thing you can't do is do nothing. Because when this thing comes in, your behavior, it will feed into the impression the court may have of how you dealt with it. I just don't think it's a good idea at all to simply do nothing. And in fact, I've done the do's and the don'ts listed there. Is that first one is the obvious one. Please don't ignore the request when it comes in. If you're worried about it, get help, get advice. We can help you with that. Don't respond without authority. So don't fire off an immediate, how very dare you? That's my best drafting in the whole wide world ever. I absolutely know the testator's mind completely, and they were fully compos mentis at all times. I'm actually quoting from a letter I've had before. Is that's as soon as you do that, you're doing it A, without authority, and B, just tactically. Don't overegg it. Just be honest and open about it. Respond if no serious dispute. So again, if you look at this and it's obvious that the person either has no locus standi at all, so they can't bring any claim, whatever the validity or otherwise of the will, or if you've got somebody who's just alleging a 75 Act claim that's very thin on the ground, or you've got somebody who is alleging a dispute without actually saying it. So they just say, we're bringing a claim on the basis of mental capacity, testamentary capacity, lack of knowledge and approval, undue influence, fraud, forgery, and anything else we can think of. It's not enough. You've got to go back and ask for details. Don't ignore allegations of negligence. As I say, very few wills are considered to be negligently drafted in court, but refer it to your insurers if there is any reference there to it. And then the final one is just a general observation from me, really, is try not to be partisan. and precious about your will drafting skills. Okay, we all will drafting is a difficult task at the best of times. It's done at a point in time of somebody's life, and you do your best. And there's some very talented people, and you can be very well trained, but you still might not quite get it right, because it happens from time to time. And even if it's right, it might be wrong, because somebody else is that you don't know things that have gone on within the family that may well bring it into some kind of question. So that's the not to do's. In terms of the things to do, some of it's the reverse of everything on the left list, but take a step back, take advice, conduct a self-interest conflict check. What I mean by that is you're asking yourself, am I thinking about me, or am I thinking about the client? Most of the time we're doing both, because I want to do a good job and the client needs to be represented as best ability. But if there is something in there, self-interest, step away, get somebody else, get independent legal advice to be given. Act neutrally with all the parties, absolutely given. I've seen some very aggressive executors. Don't be that executor. Respond in a timely manner. And then the last one is one that often gets lost, or people give up on it very quickly, and that's that merely because there's a dispute and there might be a caveat lodged and there might be like a news letter sat on your desk and a response that's gone out, is that what we can't forget is in the middle of this is an estate. Now, it might well be that we can't at the moment decide whether or not the estate should be administered on one will or a previous will or even intestacy. But what is quite clear is that if it starts with you and you were the last will, you need to raise the question about preserving the assets and liabilities, or discharging liabilities of the estate where appropriate. So things like an interim grant, ad collegenda bona, or the rest, is if you can get those sorted out to actually preserve and ring fence the estate whilst the dispute is ongoing, then absolutely you should be doing that. And I'm thinking particularly about properties that are left vacant and just falling into disrepair, because at some point, someone down the line, when it's all resolved and they turn around and the dispute, they've been throwing punches for a couple of years, is that they then turn around and say how much is in the estate, and then they realize that the property is worth 50,000 less than it was a year and a half ago because it hasn't been sold, but everybody wanted it to be sold. Why didn't that happen? You can see where that kind of argument goes. So definitely worthwhile looking at that. If the parties can't agree who should apply for it, then consider an independent to do that anyway. But either way, it needs to have crossed your mind, needs to be recorded, and you need to take a view on whether or not that should be done. Some final observations about file notes, which is yeah, it's interesting, because this is another part of the survey we did. On question 3 was how old, so what was the time that passed between the execution of the will and the Larke versus Nugus request being received? And that time span is graphed there. So what responses we got were that 23% said it was within 3 years, 52% said it was commonly within 4 to 10 years, and over 10 years there was 25%. So a quarter of all wills, after you've executed them, filed them away neatly, they won't be subject to any kind of dispute for at least 10 years, for 25% of the case. The median point was 8 years. So 8 years time passed between your putting your file away and a Larke and Nugus request coming in. Now, in terms of remembering that, I'm sure your note keeping and everything you do now is superb, because you're on notice that these type of things happen. 8 years ago, not so obvious. And I'm not saying you go back into all your files, but what I do say is that it's worthwhile remembering it was 8 years ago. And I think also that there's no coincidence that this volume of claims coming through now, we are seeing a number of online will type claims and Larke and Nugus requests coming through that we're dealing with on behalf of lots of various different clients. I say immediately, I'm not adverse to online wills when they're done properly. What I will say is that 8 years ago, they didn't really exist in volume. I think the last 8 years is probably, and certainly the last 3 or 4, you've got some really big players who are dealing with online wills, and in some cases doing it very, very well, and others not quite so great. But nevertheless, they are going through right now. And it's in my view that we are going to start to see over the next couple of years, probably these being tested in some way, because it's there are good parts about online wills in the sense that, you know, recording of voices and recording of conversations and instructions is great because you're actually hearing it from the witness's mouth. Not so great sometimes is understanding who gave the instructions, who was present, those kind of things. So, you know, there are pros and cons for all types of different wills, and 2/3 of people have no will. So I'm not going to sit here saying don't make one, is that making one is the right thing to do. But I still think that that's where Larke and Nugus is actually going to start to evolve a little bit going forward in the future. And I think for me, one of the things I would say to people is, if you haven't already, think about ways in which you can protect yourself in respect of wills when you've got those kind of requests and claims coming through. I always feel like I need to give a crime watch, sleep well warning, because I'm very conscious that I'm throwing at you all a whole series of, goodness me, this is a problem, and what about that, and the rest. So here's your crime watch, sleep well, kind of end of the day for those old enough who remember it. Larke and Nugus only deals with disputes about the validity of a will. As I say, the will file may well be relevant to other types of claim, but it's not directly a request that you would normally make. Why is that important? Well, I would refer you to my Venn diagram on the right, which is probably more certainly older than Crime Watch. Is the Venn diagram itself demonstrates hopefully the nature and the type of the probate claim and the ground upon which it's based. So what we've tried to do there is show how a claim for mental capacity invalidity is by far the biggest. In our view, there is an overlap with a smaller claim, lack of knowledge and approval. There is an overlap with undue influence, which is very much smaller. You've then got fraudulent calumny, which is again another smaller section of undue influence itself. You get the picture. So you've got fraud and forgery, you've got revocation, and then formality, irregularity. So those are the main claims that are used as a basis to overturn a will. Outside of those is the 1975 Act claims, which you'll all appreciate are, I suspect, at least 50% of all claims are 1975 Act claims. So you would not expect Larke and Nugus request type letters coming. You might get requests for disclosure, but not the kind of same onerous problem that you've got with Larke and Nugus requests. So there's not as many as you think, perhaps. And doing some basic numbers is 8,000 plus grants were issued at last time I looked at the numbers, and I have 150,000 grants for that same year. So you're talking about loosely, I know not every Larke and Nugus request or dispute starts with a caveat, a lot of them do, but we're talking about at least 5%, but probably anecdotally no more than 10% of all estates are subject to some kind of dispute. So I would suggest that probably 5% of the estates that you deal with, you may well look to get a Larke versus Nugus request coming in. So for every 20 that you do, you might get one coming through. And the other thing I'd say, number 3, is that, you know, I've seen the list of people who are on this call, is that you are all, you know, experienced enough to know when you're making a will that the family dynamics and the will provisions and all the will provisions are such that as they leave your room, you're thinking, gosh, they'll be back, but they won't be seeing me, because you've advised them that there's a problem. You've advised them that missing out your spouse is not a good idea on provision because there's going to be a claim. You've advised them about the proclivity of people to bring claims for adult financial beneficiaries. You'll have been through all of that. You'll have seen the blended family. You'll have seen inequitable gifting to children and what that does. You've seen the failing testamentary capacity, and I'm sure I'm not going to advise you on the golden, but tackle through. You will go and get them testamentary capacity tested. What you will know, and if you know, then you are on notice that that's more likely the file that is actually going to be looked at in 7, 8, 9, 10 years' time. So you're on notice to keep your notes good, strong, tight, do everything that needs to be done and put them on there so that when the Larke versus Nugus request comes in, it's responded to easily without worry. And I include there, I don't think it's a Yorkshire thing, but it's nevertheless something that stuck with me, is that sod's law will always trump most statutes. So what I mean by that is that case, or it would happen with that, or it had to be that case, it is always the same. So if you're working through sod's law case and you get to the end of the will, you try to get this person to sit down 7, 8, 9 times, to execute their will and they keep changing it, you know that's the one. You know that's the one that's going to come back in 7 or 8 time. So again, you are on notice to try and fix that whilst you can. I don't know, Lindsay, whether or not you've had enough time to come back with I'll put you on the spot here with how many. You have. So how many people have said no, they haven't had one?
27 out of the 97 that have been here.
Right, okay, so I'm going to say that 25% of people, I'll adjust it slightly, haven't had a Larke versus Nugus. So that means that 75% of the people on this call have had a Larke versus Nugus request come in. That is, I know that it's not statistically the most soundest way to do it, but I actually wrote down, but I guessed that there will be at least 60%. So it's higher than it was. So 75% of people on this call have had a Larke and Nugus. That's it. And I suspect if we ask the question, how many, the volume of them will have increased as well. So it's not a new phenomenon, but it is. There's no doubt about it that it is starting to increase. And finally, from me, is that for me, the practicalities of preparing a Larke versus Nugus statement are pretty straightforward. Find the file, find the will drafter, and then take the time to draft and get it signed off. On the right-hand side there, a couple of graphs. Again, questions 5 and 6 of the survey. Bear in mind, this is 4 years ago. How long in total does it usually take to complete a Larke versus Nugus response? For the 75% of people who have already done it on this call, ask yourself the question, which one of those 3 do you fall into? Is it less than an hour, speedy typers, or was it 2 to 4 hours, which was nearly 85% of people, or more than 2 hours who were super careful or it was very complex, and I went to 12%. So you can see that in terms of time taken, that's 2 to 4 hours. You didn't used to be able to, or certainly it wasn't easy, to claim fees for doing that, just as a note. Not so now. In fact, on the most recent practice note, it's actually says quite clearly in there that according to SRA regulations, is that you're perfectly entitled to charge a reasonable sum, and a reasonable sum for photocopying as a disbursement as well. So bear in mind that when these requests come in, you are perfectly entitled to actually charge for that. And quite frankly, if you're responding to speculative stuff coming in, but you decide that actually it's expected, but I've decided it's serious enough to do, then get paid first. Fairly obvious thing to say is send the invoice, ask them to pay, and tell them you will release the Larke Nugus statement from yourself on receipt of it. In terms of we asked 3 years ago, do you think the number of Larke Nugus requests is going to increase in line with the number of actual claims being brought? No surprise to learn there that 86% of those people who were asked said yes. And in fact, the numbers have shown today that that probably is true. We have, and I've alluded to it earlier, and you'll see a nice little logo there called Larke, is that we have tried to help people making wills. As you know, IDR resolves disputes when they crop up. More and more, we're trying to harness tech to try and help people prevent claims in the first place. And one of the things that we highlighted is really at the will making stage, is that with the increasing number of Larke versus Nugus requests coming in, and knowing how we can get evidence out of files, and the evidence tends to be unhelpful, really, a lot of the cases, is can we help people here? And we produced a standalone piece of software that will take you through the instruction taking, drafting, and execution stages. It is not will writing software. It's not designed to be. It's designed to stand alongside however you draft your wills. And the idea is it will take you through have you, should you, do you, can you upload, and then it will produce a Larke versus Nugus statement. At the end, you just hit the button and it will produce it at the same time as the will that you have produced. So you can actually get the testator testatrix to sign it. So you've got this Larke versus Nugus statement that's signed at the beginning, which also extends to giving permission to who should be able to see it. And we've thrown in some insured coverage for that. So if it does then get challenged, then we will help you and advise on that free of charge at the beginning to see where it goes. So again, we're trying to help at the front end. Have a look at it by all means, but the bigger picture is hopefully being made a little bit clearer from today. So I have I think the next slide is IDRN. I think before I move on to that, is it worth perhaps, if I'm going to stop screen sharing now, Lindsay?
I think if you stay screen sharing, sorry, so that because and then your slides are up for the IDRN, if that's okay.
Yeah.
There's a couple of questions for you for that, if that's okay.
Yep.
I'll just read them out. So Hardy has asked, does it have to be authority from all named executors, or can it be the principal executor only?
I've just found the questions. Thank you. So that's
okay.
It's a really good question, Hardy, because in short, executors are supposed to act as one. So you can't have one going off and acting rogue. So the answer is it should be all the named executors. What often happens is if somebody drafted the will and placed themselves or their firm as executors and there's no second one, so it's just partners of, or somebody else has died, you might be left with one. And if you are left with one, then it's that person's call. But in terms of more than one, like any decision, you need to make sure that you are together. Or I don't want to. This Colin James has asked, at what stage should I inform insurers? And I think hopefully my slide helps with that, is that the short answer is if you find yourself asking the question, should I? My gut feel always tends to be just do it. Is just notify it. You know, a notification of insurance claim or negligence claim is always easier to cross out later on. Won't affect your premium. I am sure if it's spurious or you think actually I can cross it out now, the reverse of that is not what you want, which is they turn around and say, well, actually you knew back then and you should have notified, and as a result we refused to indemnify you. So I would, when you get the letter, look at it. If it discloses or suggests negligence, then at that stage you should report it. Don't be shy when you report it, explaining why it's a load of nonsense, but you're reporting it because that's what you should do. No harm in doing that, but I would always take the view is better warned than not. I think, there we go. Ian Poole, are the executors obliged to provide a copy of the testamentary capacity report if one was obtained at the time of the execution of the will? What I would say, I mean, again, good question, is I would say that the testamentary capacity report, the idea is inquisitorial again. So going back to the basics, is that the court wants you to give enough evidence on behalf of the estate on a serious dispute. So you're going to get past that first hurdle. So if you're satisfied there is a serious dispute, so you have somebody that alleges that there was a lack of capacity, you turn around and say, well, you know, I've got a capacity report to do it, then my view would be is that if it's serious enough for you to respond to Larke versus Nugus, and that testamentary capacity report was part of your execution process and your will file, then you disclose it, would be my view. Because if you don't disclose it, what then is that one assumes that it's a positive testamentary capacity report that says, yes, absolutely fine to make this will. What you don't want to do is end up 6 months, 7 months down the line where you've got a pre-disclosure application in front of the judge and the claimant saying they won't give us a will file. It makes us even more suspicious. Judge agrees with them and says, yes, disclose the file. And you go, haha, I've got a medical report that confirms complete competence. Judge is going to turn around and not praise. He's going to turn around and say, oh, she's going to say, well, if you did disclose this at the outset, clearly there was a serious dispute, then all of these costs could have been saved. And that really is the push against for in my view, for Larke and Nugus, is that behaviour types is what then results in costs order being made. So hopefully that helps you. I've got one final one here, I think is, Brian, got some more.
There's quite a few here, Mark.
Yeah. You shout at me if I'm running out of time. Copy slides fine. If I take to conversation between myself and a client and did not mention to the client I did so, would that take not be accepted in a Larke versus Nugus at a later date? Wow, that's. I mean, first and foremost, I as was done on this call, really, is that I would always, I know it's advice after the event, but I would always advise a client that you're recording. I've had it the reverse way around, actually. I've had a client record me in a first interview, which you know, if they ask to do that, that's absolutely fine. They can record their advice so you can replay it, but to not tell you and then just hear it as it goes click under the table, which is what happened to me, it just feels a bit odd. If you taped it, it's not a criminal court, so you're not talking about, you know, sham, you're not talking about sabotage, you're not talking about those kind of things. I suspect that I mean, it's the discretion of the judge, but I suspect that it will be allowed because, again, inquisitorial, if I want to find some information out that will help, then maybe it would. How strong it would be will be a question of what's on it. It's that how is the individual led? You can't really tell how they appear. I know a lot of people video their first meetings as well. We are getting more of them these days, but they tend to be sort of videos of the entire room talking rather than just one or two individuals. So in short, I can see a situation where it would be, Jeffrey. I could see that happening as a natural. I'm sure you don't, but as a natural course of events, I wouldn't be doing that without informing them first. We haven't touched upon it, and it is a full talk actually about data and personal data requests, GDPR, which is you can get some interesting stuff that pops up there. Is if someone hits you with a GDPR request on behalf of the estate, do you have to provide the information that's stored, and what do you need to redact, and those kind of things? But again, that's a different conversation. Sharon Harding, would proprietary estoppel create this to happen? Proprietary estoppel, as you probably know, promise made, reliance on that promise, and someone suffers a loss. Classic example, in fact, was my first ever contentious probate case, was where farmer promises son farms, father dies and doesn't give it to the son, gives it to the three daughters, which is what happened. Promises can be enforced, but in terms of Larke versus Nugus requests, I think a will file has to be relevant evidence. It has to be, is there anything in there that can help us understand why this promise wasn't fulfilled, or was there some other thing behind it? In fact, on a case that was reported that we ran a case called Suggett versus Suggett, there was, well, by the time we got the will, we realized that the will itself had a provision in it that simply said, I will give everything to, if my daughter, that's right, if my daughter thinks my son is a good farmer, then she should make sure he gets the full estate. And of course she got it, unless she said, yes, he was a good farmer. I'll let you decide what she said, but we ended up in a successful trial on proprietary estoppel. But that will file undoubtedly was crucial. It was really important stuff. But was it a Larke and Nugus request? No, it wasn't. It was basically, can we have this disclosed to us, please? And in the end, all the parties agreed that should happen. Elaine Hughes, thank you very much indeed. The link to Larke online is incorrect. It should be .co.uk. Thank you for that. So it's www.larkeonline.co.uk. I think that's everything, Lindsay, unless I've missed anything.
I think, sorry, there was another one off Hardy saying what would a reasonable cost to be charged for completion of the LVM.
It depends on this. I mean, so far as costs are concerned on that, it really depends on the amount of work. Is that one of the questions that was on the survey that we didn't put in there was the average cost of the hourly rate of the individual doing it, and it came in at about £250 was the average hourly rate. So back 4 years ago, before people were actually asking to be paid for doing it, they would come in at 250 times 4. Suddenly it was £1,000 worth of work they were doing and not getting back. Now we're in a situation where you can get it back, but you're going to have to justify what it is you're going to do. It's not a small piece of work in my view. It's a good, we can see 2 to 4 hours. So if you look at that and say, well, what's a reasonable hourly rate for that for a solicitor? Well, you're going anywhere from 200 to 300. I suspect that most people, and because it's personal to you as a will writer, it's not something you can delegate to a junior. It's you. So for me, it'd be very difficult for somebody to argue against paying you 2 or 3 hours worth of work. So that's suddenly 500, 700. I'm not suggesting we all go and charge huge amounts, because you've got to take a view, haven't you, ultimately? But the guidance is very thin on the ground, and I've only had one where a client refused to pay the lawyer's fee. He raised a fee of £750 plus VAT for doing the Larke versus Nugus, and he wouldn't release until the invoice was paid. And in the end, client had to capitulate and pay it because there was no way of enforcing it. No court was going to turn around and say, no, you can't do that. And certainly no one was going to spend more than £750 taking it to court just to get the £750 reduced. So I hope that provides some guidance, but I would suggest that this data here shows 2 to 4 hours is regular, 2 to 4 hours times an hourly rate, which you might want to discount because it's your own file, it's up to you. But I don't see why that can't be raised and be asked for.
There was one final question, Martin. Louise Whitfield's asked, what should happen if executors are also beneficiaries and two executors are disputing the will and the other is not?
Yeah, it's a good point, isn't it? Is that if you've got two executors who are disputing the will, then both executors would have right to have access to the will file anyway, wouldn't they? So you would have a situation where the executors are, under the terms of the will, they have authority to release it to themselves. They couldn't do it individually, they'd have to do it to the pair of them. Query if you've got, it's more complicated if you've got one executor and a beneficiary, and the benefit as the same person, and then a second executor who's not in dispute with the other beneficiary is. So you're having to flip those hats again, which is not uncommon with contentious probate, is that you find with most families, whoever's appointed as an executor invariably will probably be some kind of beneficiary as well. So you're going to get that kind of swapping of hats. And it comes back to case-by-case conflicts of interest, is that we've had situations where estates are quite modest, and we've taken the view that we're happy to run representing both whilst ever there's no conflict, but walking and asking ourselves that question every time we dip into the case, simply because it wasn't worth getting another set of lawyers involved to the estate dispute. And we told the other side that was the case. If it was a big estate, we wouldn't think twice. We simply go, right, okay, because it's a bigger estate, there is bigger scope. There's no good reason really why we should have to try and walk this line. Let's separate out and do it that way. There's always a way to get the Larke and Nugus through, I think, is the point, is that if it starts to get messy and complicated, then ultimately you can get an independent appointed or a court order to sort it out. But most people take the view, when it's explained to them properly, is that, look, we're not saying you win, we win. What we're saying is there's no way a court is going to not want to see the circumstances and the evidence surrounding the way in which this will was made. Now, if that individual is a lay individual who helped draft the will and is also executor and is also beneficiary and the rest of it, then you can see how that any evidence that person gives would be unreliable anyway, because they are never going to be unpartisan. They're going to be of a type that's going to self-serve. So you end up then going to court, getting an independent appointed, and away you go. I hope that answers.
Yeah, that's all the questions. So
thank you, everybody. Any questions at all following the event, please do get in touch, and I'll hand over to you, Lindsay, just to bring things to a head.
Yeah, can you just go to the next slide?
Yes,
okay?
Yeah.
So we've had quite a few people asking, whilst this has been on, if they could have a recording of the session, if they could have the slides. So I'm just going to add into the chat the link for the IDRN, because the recording and the slides will be added to the CPD section of the IDRN. Probably quite a few of you on here are already subscribers to the IDRN, but if you're not, please do subscribe. It takes just a few minutes to register, and you'll get updates on all of our clinics going ahead. The IDRN is basically a free support tool and a referral tool for anybody who works in family succession, and it provides all resources and content and training should that contentious case land on your desk. We've also got a triage area which covers off what to do in our 4 most common contentious issues. So 2 of them are actually the 1975 Act claim and Larke versus Nugus. So that area just gives you quick guides and download guides on what to do and things that you can hand to your client. There's also a fast track area, so you can fast track a client across to us should you have a client who's got an issue. And we've also got legal tech tools, which includes access to Larke Online and the IDR Claim Checker, which Martin highlighted before. So the IDR Claim Checker is our simple online form that assesses the strength of a claim within minutes. And what happens is you get a report with a yes, no, or maybe as to the strength of that claim. At the moment, we're enhancing the checker and developing it so that it basically can effectively triage all kinds of claims, so probate claims, executor claims, and it will provide additional guidance on what to do in these areas. And it will also give you that yes, no, or maybe report response as well. So we are looking to, well, that will launch again at the end of September. And I think Martin mentioned this before, we've got one for charities that's coming out. Actually, that is next week. So really exciting. So that's on its way to you. So please do subscribe to the IDRN to be updated with all of that. We send out the IDR news on the 1st of every month, so you can access all of this stuff quite easily. And next coming up, so would you mind flicking to the next one? The next session is in October, and that is for our Contentious clinic. We'll be doing will validity challenges, and this is the first one that's being hosted by one of our solicitors, Georgina Coates, and she'll be supported by one of our partners, Richard Thomas. So that is on Tuesday the 31st of October at 12 p.m. So if you register to the IDRN, you can register to that session via the event hub. So please do so. Thank you so much, everybody, for coming along, and we hope to see you at that next session. Any questions on Larke versus Nugus, please do direct them to Martin, or any questions on any of the legal tech, the IDRN, or the claim checker, please send any queries across to myself. Thank you.
Thanks, everybody.